Hello, John Dove here, and welcome to the latest episode of the Speed Mooting Partners in Crime podcast. This is episode 10, and we hope you enjoy the episode. On today's episode, Hayley and I were discussing a number of topics, including the latest from the Advocacy Club, our recent play-in mitigation competition, which took place on the 1st of June. We give a little hint about our next upcoming in-person speed mooting competition. We discuss a number of legal topics, which we hope you will find useful, both civil and criminal. So from the criminal point of view, I discussed the Goodyear indication. In relation to civil law, we discussed the various tracks that are used in civil litigation. The tracks are there to allocate how a claim is dealt with and litigated. One thing you might notice today, there was a bit of a WWE theme. We don't know how this happened, but somehow a number of the things we were talking about were linked to WWE in some weird way. So it's a bit bizarre, but a bit funny at the same time. So we hope you enjoyed today's episode. Welcome to the podcast. And we are recording. Welcome to the podcast. I'm John.
And I'm Hayley.
Here we are, episode 10, Hayley.
Episode 10, double digits.
Double digits. How on earth have we done that?
I don't know where the time's gone, to be honest.
No, me neither. Well, I'll tell you how we've done it. 9 weeks have passed since the first episode. So,
yep.
Yeah, I mean, you know, in real terms, that's what's happened. But yeah, as you say, time has absolutely flown.
Before you know it, we'll be sat here and it will have been 10 years.
Yeah, I was going to say episode 100, but yeah, 10 years. Imagine that. Imagine if people are still listening to us in 10 years.
Imagine if we're still sat here doing this in 10 years.
That'd be crazy.
Hopefully we're in a bigger house. Maybe sat on in a holiday house in Tenerife or something.
Maybe. Yeah, that's it, yeah. Hopefully the episodes in 10 years are coming to you live from Tenerife. Yeah, who knows? But yeah, episode 10.
Episode 10. So, who are we naming this after, John?
So this week, we're sticking with Formula 1 for now. So
went to football last week.
Well, we did, didn't we? Well, I mean, I started with Formula 1 and we gave an honourable mention. So This week it's primarily Formula 1, but I will make an honourable football mention.
Is it going to be Everton again?
Of course it will. So it's Formula 1, Pierre Gasly, race winner.
Yeah.
Yeah. He won the Italian Grand Prix in... Now. What year did he win the Italian Grand Prix?
Don't know.
I have a feeling it might have been 2020, you know.
Well, when we're editing this, I'll confirm the date.
You can confirm the date. But anyway,
just in case anyone's watching, I need to know.
Yeah, or there'll be someone shouting at the screen, John, it was this year, surely you knew. Yeah.
Okay, so Pierre Gasly,
you might remember the race actually, because the race got red flagged, so everyone had to come back out. And everyone on the formation lap, everyone with the exception of Lewis Hamilton, pulled into the pits. So you had this really weird situation where you had just Lewis Hamilton on his own on the starting grid waiting for the 5 lights to go out, whilst everyone else is sat in the pit lane. Yeah,
it does ring some sort of bell, yeah.
Yeah, so everyone, I can't remember which way round it was. Presumably it was people switching from wets onto slicks. And Pierre Gasly went on and won the Grand Prix.
There you go.
Yeah. So so that's our Formula 1 reference. Honorary mention, in his second career at Everton, Wayne Rooney wore the number 10 shirt.
Oh, I don't mind Wayne Rooney, actually.
Yeah.
I like Colleen.
Yeah. So, I mean, Wayne might get another mention on episode 18 as well.
Right.
But, yes, this is the Pierre Gasly and Wayne Rooney episode of the Partners in Crime podcast.
Here's a challenge for you. Next week's episode, you have to find a Liverpool player to name it after.
Well, number 11. That would be
don't spoil it.
I won't spoil it. Okay.
Speed Squad, as you are now affectionately named. If you know who it's going to be, let us know in the comments.
Well, if anyone's a Liverpool fan, and apparently most Liverpool fans actually live outside of Liverpool.
Oh.
Yeah, apparently so.
Well, I think most Liverpool people are Liverpool fans as well.
Yeah, they are. But what I mean is, of all the Liverpool fans in the world, more of them live outside of Liverpool than within Liverpool. So I don't know why. It's one of those teams that non-Liverpool people like to support, but
Yeah, but I think in Liverpool as well. Surely there's got to be more Liverpool supporters than Everton supporters in Liverpool.
Yeah, you could be right. I don't know.
It doesn't really make sense then, does it?
No, I know what you mean, though. Within Liverpool itself, the more people support Liverpool or Everton.
Yeah.
Yeah.
No, but that whole thing can't make sense then, can it?
Why?
You're saying
No.
more people outside of Liverpool support Liverpool than in Liverpool.
No. You're talking about two different stats here. Right. But the reason I was mentioning it is because Liverpool's a fairly famous team, all the rest of it.
Yeah.
So the number 11, I suspect people
will know who it is.
Well, there's loads of people who've worn the number 11 shirt, but there's a pretty popular one that people might know.
Huh. I mean, I'm a Liverpool supporter and I don't know.
You'll know it.
Okay.
You'll know.
I will. So that means it's either going to be...
Well, don't spoil it.
Okay. Well, when we start next week, I will guess.
Yeah. Well, anyway.
Moving on
from sports and football and Formula 1 and all the rest of it.
Yep.
Let's get on to the law.
Let's do it.
So, we had a busy weekend, didn't we, Hayley?
We had a very busy weekend. It's Monday.
It's Monday.
I just can't keep track of the days. And this is why, because it was such a crazy weekend. So
it really was.
It's Monday evening.
Yeah.
And I still feel jet lagged from the weekend.
Yeah, jet lag, that's how I describe it. Jet lag from the weekend.
But it was a brilliant, brilliant weekend.
Yeah, it really was. For those of you that don't know, we had our play-in mitigation competition this weekend.
Yep.
And this was our record-breaking competition. Our biggest ever. Most number of competitors in a single competition.
Mm-hmm.
So it was a fantastic day. We thoroughly enjoyed it. Do you know what I've just noticed, Hayley?
What?
We were sat the other side of this table for the competition, weren't we?
We did, didn't we?
So I was sat where you are and you were sat where I am. So, for those of you that don't know, the play mitigation competition was a competition where competitors performed pleas and mitigation.
Get out of town.
So, you might be wondering, what is a plea and mitigation? Well, let me tell you. So, the plea and mitigation is a piece of advocacy regularly performed in the criminal courts, both the magistrates and the Crown Court. So, when you've got a defendant that's either pleaded guilty or has been found guilty of an offence, their representative, whether a barrister or a solicitor, will present an argument to the court to try and, mitigate, as it says on the tin, and therefore try and obtain the best possible sentence that they can for the client. So that involves dealing with personal mitigation, so expressing personal mitigation that relates to the offender themselves. That includes mitigation in terms of the actual offence itself, so trying to set out why the offence may not be as serious as it first appears at first blush, and also, and crucially in relation to this problem, dealing with the sentencing guidelines. For most offences, the Sentencing Council have a set of definitive guidelines for offences. So not every offence has a set of guidelines, but most do. And what normally happens with each offence is you'll have what they call culpability. So that looks at the offender's culpability in relation to that crime. So effectively their involvement in easy terms. And you normally have three brackets, A, B and C. And A is the most serious, C the least serious. And then you look at harm as well. So harm is the actual harm caused. And then once you take the two together, that's where you know where it falls on the matrix. So, for example, if you had an A1 offence, that would be the most serious. Or if it's an offence that only has three brackets for culpability, 3 for harm, C3 would be the least serious. Some offences have more. I think fraud offences have sort of 5 or 6 levels of harm on the guidelines, but most tend to have 3 and 3. So that was certainly one of the things that the competitors needed to do at the weekend, because within our fictional scenario, that the more serious offence was handling stolen goods, the prosecution pitched it in the bracket A1.
Yeah.
The defendant was looking at a fair few years, and the job for the individuals in the competition is they needed to bring it down to about an A2. I think sentences of more than 2 years can't be suspended, so the competitors needed to convince the judges to go 2 years or below, concurrent sentences for both offences on the indictment, and then ask the court to suspend.
Yeah. And I've got to say that the finalists, we had 6 finalists, didn't we? And they always perform in the main Zoom room so everybody can watch. The calibre was fantastic. I think every one of those finalists could have performed that in a real courtroom to a real judge. And I think they all would have got what they were asking for. They all would have got a suspended sentence.
I think so, yeah. Watching all 6 of them, they were really good. You could put them in a Crown Court tomorrow, and those pleas of mitigation will be absolutely fine. It's frightening how good
I know
some advocates are. And the other thing as well is we were speaking to some of them, weren't we, while we were waiting for the judgment, and I don't think any of them were on the bar course.
No, they were all. I think they were all undergraduates or GDL.
Undergraduate GDL. I think there was one lady who was on the SQE. So absolutely impressive. And for most of them, it was their first time trying any form of advocacy.
Yes.
One chap was a first year undergraduate.
Yeah.
And he'd gone all the way through, beating all those people and got through to the final, and his performance was incredible.
I know Oscar, who was runner-up, it was his first time ever doing any advocacy, wasn't it?
That's impressive. I mean, if that's his first time doing advocacy, just imagine what he's going to be like in a couple of years' time when he's been practicing.
And they're just flawless. That's always, I think, what makes shows off the skills, when they're just so natural, so flawless, and they're so conversational. Yeah. When they're delivering the submissions.
And that's the thing, particularly with a plea mitigation, because you need it to seem quite conversational. I can't remember who was saying this, I either read it or was watching somebody talking about advocacy, and they said that, with the most persuasive advocate, when you're listening to them, it's almost as if when you hear them give their submissions, you're thinking, oh yeah, of course, well, that's what that person's saying is obvious, of course, and it's because it's so conversational, it's just so matter of fact, that, of course, I will go with that, and that's the way a lot of those...
It's so believable, isn't it, because you're with them every step of the way, so when they say something like, if you don't suspend this sentence, you're going to send them down a path that they don't want to be on, and you're like, oh God, yeah, of course you've got to suspend it. It's so good, those tactics.
Yeah, it really is. It's getting close to tugging on the heartstrings a little bit,
isn't
it?
Yeah.
Not quite as theatrical as a jury speech, but still, you've got a bit of passion and empathy within the submissions.
So that was the plea mitigation competition.
So that was the plea mitigation competition, and I tell you what, I think we did a good job between us, Hayley, because we were managing triple digits in terms of the number of people on one Zoom call.
Yes.
So we dealt with registration in the morning, making sure everyone was there, and then we had 18 breakout rooms to manage, where we had judges coming in and out. Well, not judges, the competitors coming out throughout the day to see the judges. So
yes.
Hayley was in charge of the phone. She'd be liaising with the judges. Right, John, room 5, they're ready for the next one. Perfect. I'll shout them out. You're in. Mark it off on my spreadsheet, the trusty spreadsheet. Mark them in yellow when they're in the room.
We've definitely got it down to a fine art.
We really have. It's going well now.
And every time we open up and say, okay, let's make it a little bit bigger, and we're like, oh, is this going to be too big? We finish and think, let's make it bigger.
It could have been big. Let's give more people more opportunities.
Yes, yeah. So I don't think that'll be the limit for us. We'll probably go even bigger next time.
I think you'll see bigger competitions from Speed Mooting going.
Yeah.
Should we leave it alone? Should we back off? Should we play it safe? Nah, you think let's make it bigger.
But no, it was a fun day, and I think just to come back to something we were mentioning there, a lot of the people in that competition, some of them were first timers and they were quite natural. And that's great. And if that doesn't apply to you, don't panic. Because I certainly fall into the camp of being someone who's not a natural when it comes to advocacy. Because, I think back to first year, I did my first moot and I was terrible. I had all the classic traits of somebody that's not done public speaking before. So reading from a script, speaking even quicker than I speak on the podcast, if you can imagine that. No eye contact. No intonation in the voice, just not interested whatsoever. So all the classic things filled with filler words all the way throughout. And it was over time that I was able to improve. But funnily enough, I think I only really improved sort of once my legal education had finished, because that's when I joined the Speakers Club, and that's when, so ironically, it was in a non-legal context where my advocacy improved. And that's part of the reason we've set up the Advocacy Club, isn't it?
Yes.
So people have got that opportunity to practice fairly regularly. They're dealing with a variety of scenarios. They're dealing with people in a similar situation to themselves, so it's low pressure. If there was something like that for me way back when, that would have been fantastic.
Yeah.
But the reason I mention that is to say that if you feel like you're not a natural, you feel like you're struggling with your public speaking, your advocacy, don't panic, because you can always improve. It's just about practice and taking those opportunities when they come.
Definitely. And even the ones that get through to the final, we often hear our judges say, don't we, that we've watched them all day. If the ones that have had them in the first round to the ones that see them in the final, they've improved like through that day.
Yeah.
Because by every time they go through, a judge will give them a different piece of feedback. That was really good. You could do this better. And the ones that are really, really are exceptional, the ones that can tailor that feedback and adapt and adapt and adapt. So
Definitely.
You'll always get really good feedback from the judges. They'll always tell you something you can improve upon, something you're doing spot on. So it's really valuable. Even if you don't get to the final first time round, you will still have learnt loads and you'll leave a better advocate than you came.
Of course you will. And that's why we encourage the judges, and we've been doing this for probably 7 or 8 years now, encouraging the judges to give feedback to every single person that they see.
Yeah.
So, you know, as soon as they finish their submissions, we say to the judges, give some feedback, you know, tell people what went well and what can be improved upon. So everybody's getting some value from taking part in the competition.
Yeah.
And as you say, if they go through to later rounds, well, they've got something to work on to try and tweak the submissions and make them better. And if somebody does turn up and they're knocked out first round, well, do you know what? At least they've had some value. At least they've picked up.
Yeah.
And they're not sitting there thinking, why did I lose? You know, so at least they're getting value from the day.
Yeah.
Hopefully.
No, definitely.
No, 100%.
Yeah, so that was our Saturday day, wasn't it? And then we finished with our little tradition now seems to be going to a celebratory Indian, doesn't it?
It certainly does, yeah. The local curry house.
We'll
give them a
house.
shout out, the Spice Ways on the Chillwall 5 Ways, and then obviously a little drink in Weatherspoons afterwards as well.
Of course.
Chillwall 5 Ways.
Chillwall 5 Ways. It's got to be a spoons, hasn't it?
Yeah, absolutely. Can't beat it. So that was a nice way to round off Saturday, wasn't it?
Indeed.
Yeah. And then catching up on emails on Sunday, wasn't it?
Catching up on emails. We still, there's a lot of after competition admin to take care of, isn't there? But you know, it's all part of the journey, and we
enjoy. We wouldn't do this if we didn't enjoy it.
No,
so.
definitely not. And we couldn't do it without our judges who take the time out to come along and judge on the day and deliver all that feedback that we've just been speaking about. So it's a team effort. You're all part of the Speed Squad.
You really are. Yeah. So and talking of the Speed Squad, you know, we've got so much coming up actually, this year, way beyond competition. So many other events, socials, things like that. So we're going to be slowly but surely making certain announcements, and we've got a massive event into this year, which you may hear details next month, I would imagine, Hayley.
Yeah, it should be next month.
Probably next month we'll be making details about announcing details, but it's nothing like anything we've done before.
No.
It's going to be our biggest ever event, and it's going to be very valuable to many people. So I'm looking forward to making some announcements about that. But we've been working hard on that in the background for some time, haven't we?
Yes, we have. It's all coming together. So we're at the precipice of ready to launch, aren't we? But we want to make sure that we've worked so hard on this. We want to make sure the timing's right and everything's ready for launch. But it's not too far away now.
Not far away at all. Not far away.
But what we can announce, or we will be announcing first, is our next in-person competition.
Yeah.
So we gave a little teaser, didn't we, last week, saying it's coming back to London. Maybe the next teaser, should we say what month it's going to be in?
I think so. Let's do it. So our Autumn Cup, so this will be an in-person speed mooting competition, follows the same format as the National Speed Mooting competition. So you get the bundle the night before, all the case law, all the legislation, pre-drafted skeleton arguments, all included for you. And they go out the night before to give you that idea of last-minute prep like you would have in practice. That will be taking place in September. September, so not that far away, to be fair. And we will be announcing the details of that competition probably in the next week, I would imagine.
It's going to go to the mailing list first, so another shameful plug of the mailing list.
Yeah.
Absolutely free to join, free to subscribe. speedmooting.com/contact and join our mailing list, and you'll receive the details before anybody else does. So that will happen maybe end of this week, beginning of next week.
Yeah, I would imagine so.
And then it'll go public, and they're always so popular, the in-person ones.
Yeah.
I mean, we love the online ones, don't we? But we do say there's There's nothing like
There's
the in-person.
nothing like the buzz of an in-person competition.
Yeah.
You just can't describe it, and then you get there and, you know, the sort of the final, because obviously we get there nice and early, and from about 8:20 to about 8:50, when you're just waiting for people to come in, it's like that final calm before the storm, and then your judges and your students, your competitors sort of swarm in, and it's just such a buzz. And there's nothing like when we get to just after 9:00, everyone's in the main lecture theatre waiting for the briefing, and then we kind of go in last. You know, we've just signed the last few people up, and then ready for that talk.
That's it. And it's just go all day, isn't it? Yeah. We have lots of other, as well as the competition, events on throughout the day, networking events, educational events, etc. Full details will come shortly, so we won't give too much away just now. But it's almost like a huge big workshop day, isn't it really? It's not just a competition.
Yeah, because as we say, you know, some people may be knocked out in the first round because we have 128 people, 7 rounds, so unfortunately, some people will be knocked out in round 1. There's nothing you can do about that. But what we do is we make sure the day is as valuable as possible for those people. Our last competition was at Liverpool John Moores University. Brilliant host for the competition.
Yeah.
And Matt Curtis, who's head of law at BPP Manchester, came along and he delivered a masterclass on the plea mitigation. So he used one of our old problems and explained to the students what the plea mitigation was all about. Plea mitigation on a disqualified driver.
Right.
Disco driver, as we call them in the industry.
Really?
Sounds like someone's going to a rave, doesn't it? And he made it quite interactive, didn't he? You know, he's asking the students, which pieces of information do you think are relevant, and you know in what order would you do things? You know, he's really interactive, and then he delivered the plea mitigation the way he thought it should have been delivered. So very, you know, absolutely incredible.
Yeah.
We were sat there in awe, weren't we? You know,
oh god,
we knew it was going to be good, but I mean, the way he delivered that, it was absolutely a masterclass.
He's the head of law at BPP for a reason, isn't he? He was so impressive, and he was a practicing
barrister. He was at the criminal bar for a long time as well. It's quite funny actually, because he was involved in a large scale drugs trial. You know, I won't name which one it was, but there were about 40 defendants involved in this. I think 3 separate trials. And we use this thing called the defence case system in the Crown Court, and we have a sidebar where, you know, barristers, judges, solicitors, etc. can put notes on there. I remember when I was briefed on the case, I went through and I saw Matt's name on there. I thought, what are the chances? So, you know, he sort of leaves the bar, I join the bar, and both end up in the same, obviously for different defendants.
It's a small world though, isn't it?
But yeah, really small world.
Yeah, so that was an advocacy exhibition, the last one. Previous ones, we've had a mock trial, haven't we? Mm-hmm. So the students have been able to watch a couple of barristers deliver a criminal trial, usually. Yeah. Q&A panel as well, we usually put that on so they can ask questions of practitioners, tutors, pupils, barristers, etc. That's always really, really good. There's always a cracking lunch as well, a networking lunch. Yeah. And we always end up in the pub.
We do.
Afterwards as well. Our little reward. Yeah. But yeah, details with that will be coming very, very soon. We're very excited. We love our in-person competitions.
We do. Now, Hayley, you, for those of you that don't know, Hayley runs the social media these days. So if you've noticed that in the past few months, the social media accounts look a lot better than they used to. You know, the posts are a bit more interactive. The YouTube thumbnails are better. It's because Hayley's taken over, long and short. And I always like to talk about some of the posts that you do.
Yes.
And there was a really interesting one this week. And for those of you that don't know, it was The Rock taking the mickey basically out of John Cena. Mm-hmm. So,
let's take a step back first and explain that John is a big wrestling fan.
Yeah, you could say that.
Not quite as big as a Formula 1 fan.
No. I dip in and out. So obviously as a kid I used to watch it.
Yeah.
And then I stopped when I got to a certain age, didn't really watch it again. And then, sort of 2013-ish, when The Rock came back, I got back into it for a couple of years. It was good, and then it kind of went off the boil a little bit, so I stopped. And then wrestling's they're calling it sort of a renaissance period at the moment. So I got back into wrestling probably about 6 months ago, I think, because it's really, really good at the moment. So if you've been living under a rock for the past 20 years, you may have not heard of John Cena. But John Cena has a catchphrase, doesn't he?
Yes.
Where he says, "You can't see me." And we thought that was quite funny because if ever you go in the Crown Court and you're not wearing your wig or you're not wearing your gown, you should say to the judge, "You can't see me." I know Your Honour can't see me, or I know Your Honour can't hear me. So we thought, wow, we've got to do a play on this.
Yes.
And there was a good video of The Rock taking the mick out of John Cena doing the "You can't see me" thing.
I'm going to put it on. It'll be B-roll in this podcast.
It'll be B-roll, so you'll see it now. So you'll enjoy it over the next 10 or 20 seconds.
You can't see me. You can't see me. You can't see me. What are you playing, peekaboo? You can't see me. I can see you. Can you see me? Oh, believe me, we all can see you.
But we just thought that was so funny. We had to include it, didn't we?
Does that happen in real life? Like, will the judge, like, if you go in and try to talk to the judge without your wig and gown, will they say, "I can't see you"?
They should do.
Yeah.
So in theory, if you were in the Crown Court trying to speak to a judge, they would be well within their rights to say, "I can't see you" or "I can't hear you." And
it's crazy, that, isn't it?
yeah. And I had a matter only a few weeks ago, actually, and I was briefed very, very last minute. I talk about this all the time. I mean, it happens all the time, and we'll probably talk about time management in a moment. But I was briefed last minute to go to a court in a different city, so I had to fly there. And the hearing was listed for, let's say it's midday. I can't remember what time it was listed for, but let's say it was midday. And I get there literally just before, so I thought, before even going to the robing room and taking off my, getting changed into my tabs, putting my gown on, all the rest of it, I thought I'll literally run straight to the courtroom and just let them know I'm here. Can we delay my matter for 20 minutes or so while I get changed, go and see the clients, and then come back and then do whatever it was I had to do? So I go into court, and the courtroom was empty, but the usher and the judge were in there, so I went to speak to the usher and said, explain what happened. And then the judge wanted to speak to me, and I said, "I know Your Honour can't see me." And he goes, "Don't worry, Mr. Dove, I can see you, it's fine."
So they can waive that. It's not a rule,
of course,
it's
not
just...
hard. Because if you go in and you're courteous like that, it's obvious that you've not had time.
Yeah.
Because you're not necessarily presenting submissions. Normally, if you were doing that, it's just go in and say to the judge,
I'll be here in 5 minutes, I'm doing this.
Yeah.
Yeah, if you went in without your wig and gown and tried to stand up and present your case, they'd probably be like, "Get out of here."
Yeah. Now, the exception to that is that there are some hearings where you wouldn't. So, for example, a bail application, that is dealt with in chambers.
Well,
So you take your wig off for that.
Yes.
But as a general rule, open court, you shouldn't be presenting your submissions without your wig and gown on. So, but if you're just going in just to ask for something, then as long as you're courteous, the judge should be okay with that.
Right.
Stemming on from that is a big part of day-to-day life for a criminal barrister. So
yeah, it always amazes me when you're briefed on multiple things and they're all happening at the same time. Sometimes, like, haven't you where, like, two different courtrooms, two different court buildings, and you've had to run back and forth between the two, and half the time is spent going in saying, "Okay, what time's this one coming on? Okay, I've got another one over there," and it's
all about speaking to the ushers. The usher is your best friend in court. And telling them, right, I've got this one here, so can we try and delay this one, move this one back in the list? And that's a big part of daily life.
You've got to keep a cool head about you, haven't you?
Yeah. Oh, yeah. I mean, if you were going to be flustered, then you'd have no chance at all. So it's all about staying cool. I was chatting to James Armstrong Holmes on the podcast, and this episode will be coming out soon. And he was saying quite rightly that quite often you'll be sat in the Crown Court and you'll be in one chair because you're prosecuting one matter, then you move across because you're defending in the next matter, then you move back across because you're prosecuting the next matter.
It's crazy.
And that's just the way it is. You're just constantly moving. So it's all about just trying to basically manage where you need to be at any one time. And so you need to, once again, it comes back to courtesy, because as long as you are courteous, you go and see all the different ushers beforehand, and or if it's open court, go and see the judge and just let them know what's happening. Most judges understand the pressures that we face at the criminal bar, and you should be okay. But that's a big part of our job, is just trying to manage your time.
Yeah, definitely. So I think we were going to talk about a couple of examples again, something from crime, something from civil, weren't we? So do you want to go first?
Yeah, I'll start. So I think
we were going to talk about is it a Goodyear indication?
It's a Goodyear indication.
Yeah.
So it all stems from a case of Crown and Goodyear. And the idea of the Goodyear indication is just when you've got a client and they've obviously pleaded not guilty, you might be heading towards a trial. but you may want to explore the possibility of what the judge would be thinking in terms of if they were to sentence. So it might be, if you were to agree a certain basis of plea, you can go and ask the judge for a Goodyear indication. Now, the judge is under no obligation to give you a Goodyear indication. They can say, no, I don't want to do that. But they may well do so, and in certain circumstances they will give you the indication. The judge will want to know the basis on which they are sentencing, and once they know the full facts on which they are being asked to give the indication, they will say what they would be likely to do. So whether they, what length of custody it might be, whether they're likely to suspend the sentence, so you get a good idea of that, and then that way you can properly advise your client from there. And it might be your client says, well, I want to take my chances, I still want to run this all the way through to trial, or whatever it might be, but at least you've got that idea there, and you know what the judge is thinking when it comes to sentence, and it may well be something that influences your client's decision, whether they want to still continue with the case, or whether they want to maybe agree some form of basis of plea with the prosecution.
Okay. I suppose you can see why a judge would be leaning towards it, because they must know if you're asking for a Goodyear, there's a chance you're going to get a guilty plea. It's going to conclude the hearing that much sooner.
Well, of course, court time is absolutely precious. So, judges, you can see why they'd be keen to do that if it's got the potential to resolve a case.
Yeah.
So, yeah, absolutely.
So that's a Goodyear indication.
That's a Goodyear indication.
For the civil side, we were just going to have a little chat about the different tracks. Okay, so the idea of the different tracks in the civil world, in my mind, it's very similar to a triage when you go to hospital.
Okay.
So you go in and they decide what level you need. So it's very similar in the civil world. So it's all designed to help, like what we've just been speaking about, to help the court deal with cases proportionately and fairly. So there's 4 different tracks. Until very recently, there was only 3, but now there's 4. So briefly, they are the small claims track, the fast track, the intermediate track, which is the new one, and the multi-claims track. Okay. And there's different rules depending on what type of hearing you have. So I think personal injury, slightly different rules. But me, in my world, so I was property litigation and civil litigation. The main reasons that they go into different tracks all depends on the monetary value of a claim you bring. So the first one, the small claims, that's generally for claims up to £10,000. The next one, fast track, is 10,000 to 20,000. The intermediate one, which is the new one, is 25 to 100,000, I think. And multi-track is anything above that. So staying in the small claims can be nice if it's it's a really simple claim. It's going to be in and out half a day, sometimes less. When we file what's called a directions questionnaire, which is where you tell the court different things, the value, how many witnesses there are, if there's any experts that are needed, how long you think the trial is going to be listed for, etc. Yeah. Sometimes we try and get it up to one of the higher tracks, and the main reason it's usually for cost recovery purposes. And sometimes, and I think you've dabbled in these hearings, haven't you, John? We can have hearings in court where we're trying to get a claim into one of the higher tracks.
And I think just to elaborate on what you're saying, when you're talking about cost recovery, what you mean by that is, so if you were to win the case, that would be having your legal costs paid for by the other side. Yeah. So effectively with small claims, am I right in thinking that each side bear their own costs?
Yes, you get a very small, there's fixed fees, so it's hundreds of pounds. Whereas when you go into multi-track, for example, if you win and they're ordered to pay the costs, generally your costs will be assessed, and we usually say recovering around 60% of your costs is very, very good. Yeah. So this is where we've spoke about commerciality before, haven't we? And thinking commercially. Yeah. If our clients have a claim and it's worth £20,000 and our costs are going to be £50,000 to get to trial, that's why we try and sell very early, because it's just not proportionate.
But as you say, I've dabbled in a little bit of commercial law myself, haven't I?
Yeah.
Did a couple of hearings like this, and these were sort of commercial cases, and the value of the claims were less than £10,000. Now, the issue there is cost recovery.
Exactly.
Because, of course, the claimants are then liable for their own solicitor's legal costs, and if they win, they don't really, as you say, they can maybe claim a few £100, but that's about the extent of it. So I did a couple of directions hearings whereby I was presenting an argument to the judge and say, well, look, although the strict face value of the claim is less than £10,000, there are other factors in the case that I'm going to invite you to consider, which would mean that this case needs to be allocated to the fast track. And then, of course, once it's in the fast track, then a different cost regime applies. So I would, at the hearing, present the argument to try and get the case into that fast track. And my opponent would, of course, present an argument to keep it in the small claims track effectively. The key argument generally stems around complexity of the case.
Yes.
Because you'd be saying, well, if you're going to be having multiple expert witnesses,
Exactly.
you're going to be expecting a trial that could potentially run over a day. Maybe if you're going to be just
multiple witnesses, you need
witnesses, whatever it might.
Specific rules around disclosure, etc., etc.
Yeah, things of that nature. So looking beyond just the pure value of the claim and looking for other reasons why it would be justified to go into the fast track. So that was must have been interesting for the judge that day, seeing a criminal barrister in his in his district judge's chambers.
Yeah, I mean, I must say it's not very common because usually the complexity of the case does reflect the value. So I've only had it a handful of times where the value is small claims, but we've tried to argue that it needs to go into the fast track or beyond. I don't ever think I've ever had success. So I think generally the court is swayed very heavily on the value of the claim.
I think so. Yeah, I think it'd be. I agree. I think it's difficult to try and get your case out of the small claims track.
Yeah, but I just always remember to say that this is what I said at the start, and it still holds true now. Back when I was a student and I was trying to grasp these claims and what it was for, what it means, I just went back to the analogy. Well, it's like when you go to A&E and you triaged. That's pretty like that's how it starts. Just categorising something so it's easy and fair to deal with.
Yeah, that's a good way to think about it. Actually, that's a really good analogy.
We've had some doctors' analogies before on this podcast, haven't we?
Yeah, and there's funnily enough, there's another one we were talking about the other day, weren't we? So
yes,
years and years ago, I was in front of a judge, and he was talking. The judge was chatting to us, and he was talking about questioning of witnesses. And sometimes it can be very easy to, when you've got a witness in the witness box, and particularly with evidence in chief, ask the wrong question. Either accidentally lead, in which case which you shouldn't be doing, or you may elicit a piece of information from a client that you shouldn't do. For example, might be you ask a question, client gives an indication that they're of good character when they're not, in which case you open the floodgates to bad character evidence, for example. I always remember a judge saying that, and he, funnily enough, received the same information from a judge many, many decades ago as well. So this is a piece of information being passed down. And he said that words to a barrister are like operating equipment to a surgeon. He says if you use the wrong word in a question, it can be fatal. If a surgeon were to use the wrong piece of equipment, if the surgeon were to use a blade when it should be a scalpel, it could have fatal consequences.
It's not what you want.
No, not what you want. So it's a really good piece of advice about how words are absolutely critical, and you need to be very, very careful when choosing your words, particularly when asking questions of witnesses in court.
Yeah, definitely.
So
I mean, for those of you that are really interested in your trial advocacy and how you handle witnesses, etc., we do have a witness handling session at our Advocacy Club, don't we? Later in this summer.
Yeah.
So just another reason why you should join the Advocacy Club if you haven't already.
Yeah, certainly is. So last week, Hayley, we were talking about the Newton hearing, weren't we?
Yep.
And
we've also been talking about WWE a fair amount, haven't we?
We certainly have, and there's a connection between. It's almost a WWE special, this one, isn't it?
I think so.
I think
we
so.
should have named it after. Did they have numbers, WWE people?
No, but maybe we could have the number of times a certain person's had the championship, maybe something like that. Maybe.
Well, we've already named this one, so we're not going to backtrack.
Funnily enough, that little segment in terms of naming the episodes, I've borrowed that from a podcast. A chap called Chris Van Vliet, and he has a podcast called Insight, and he does the same thing every episode. He picks the number and he names the episode after a famous athlete with that number. So that's where I took that idea from. So thanks, Chris, if you're listening.
We've established, John, everybody's listening to this podcast.
Everybody is listening. I think they gather together. I think all the lead podcasters get together because they think, right, what are John and Hayley going to talk about this week?
It's the Speed Squad. It's worldwide.
The Speed Squad, yeah, it really is. But stemming on from the overlap between wrestling and court. So we were talking about the Mooting hearing, weren't we?
We were.
And the story I told last week, if you weren't listening to last week's podcast, long and short, I was in court years ago I was a student at some stage. I was sat in the public gallery, and the prosecutor opened the case. The first defence barrister stood up, presented his plea of mitigation, and it was apparent that what he was presenting in terms of his plea of mitigation didn't match up with the prosecution's version of events. So it was a drugs case, and the quantity that the defendant accepted he was responsible for was different to what the prosecution were alleging. So the judge said, okay, if you can't agree a basis, then it's got to go to a Mooting hearing. And all the people, I was sat with the family members in the public gallery, not with them, but just around them, and they saw me in a suit, so they're asking me, and I had to explain to them what a Mooting hearing was. So my mate, very good mate, went to school with him, and he is a solicitor now, commercial solicitor. So I told him that story. The way he turned around to it, he said, that sounds like something Vince McMahon would say. He said, sounds like Vince McMahon said, we're going to settle this with a Mooting hearing. And you can just imagine that, can't you?
You can, you really can, yeah, you really can.
We're going to settle this with a Mooting hearing.
I tell you what, it's a good job you don't have aspirations to be a judge, John, because you would use that at some point.
Oh, all the time, wouldn't I? Oh, you could imagine me on the bench, couldn't you?
I know Michael Stokes says that there's not enough humour in the courtrooms anymore, but that's probably a step too far.
Yeah, I think so, yeah. So this month, Hayley, no competition.
Well, not yet.
Not yet. We're launching one, but we're not actually doing one this month.
I get you, yes. No competition taking place this month.
What we are doing, though, the Advocacy Club, as normal, has 2 meetings.
Yep.
So this month, it's debating our first session.
Yep.
And speed mooting at the second session.
Indeed.
So we've obviously talked very briefly about what the Advocacy Club is. Meets online, and it's open to absolutely anyone. So our members range from, I think we've got a few A-level.
We have got a few A-level students, yeah.
All the way through to, we've got a few practising barristers and solicitors. And everything in between, law students, GDL students, LPC, bar course, graduates, PhD students, we've got such a broad membership base, haven't we? Mm-hmm. And the idea, as we say, is it's all about practice. So we send the papers out a week before. There's no research, no drafting. You come on the Zoom link. We split you off into small breakout rooms. People practice their advocacy, and then they share feedback afterwards. And what we learned as well was that people network within those rooms as well.
Yeah. People make lots of good connections, don't they?
Make good connections. So if you're thinking about taking part in the speed mooting competition later this year, it's a good chance for you to practice and get some early practice in.
Definitely. And something else we've got coming up in June, which will also be very helpful for people taking part in the speed mooting competition.
We have a mooting course.
We have a mooting course.
So that will be taking place in 16 days.
The 19th of June?
The 19th of June.
Quick maths.
Yeah. I say 16 days, we're recording this on Monday the 3rd of June. It's the 19th of June when the course is. So that's going to be online, on Zoom, so you can listen to it from anywhere in the world. And I will be delivering a talk on how to prepare, what a moot is, how to prepare for a moot, how to deliver your submissions, how to deal with judicial intervention, and I'll be taking your questions as well. So if you can think of any in advance, drop them on the website. Think of any on the night, feel free to ask.
We've already got a pretty juicy list of questions for you, John.
Oh, that's good. That's interesting.
Yep.
Yeah? Oh, wow. Well, do you know what? I always like the questions that I received, so I'm looking forward to answering them. I think that brings us towards the end of another episode, doesn't it, Hayley?
I think it does, John.
Yeah, well, I've thoroughly enjoyed recording this. Enjoyed having a chat, Hayley.
Good company.
Good company. So, I hope you guys have enjoyed the episode. As per usual, if you can ever think of any questions, send them in to us. Use the hashtag AskSpeedSquad, do you reckon?
Sure.
Yeah, so hashtag AskSpeedSquad. We'll look out for them. Any questions we'll answer, or if you want to send your questions in, info@speedmooting.com, and we will answer any questions that you may have.
Yep.
Most of you probably are, but if you're not, feel free to hit that subscribe or follow button. It helps us massively, and of course it means that you'll see our content as soon as it comes out.
Yes.
So once again, thank you very much for listening. This is our longest ever episode actually, so if you're still with us, hope you've enjoyed the episode.
Yep.
And we'll see you next
next
time.
week.
So from me and Hayley,
Bye.